the full case number 25F40523. In that case, sir, the complaint does allege that on March 27, 2004, you committed the offense of operating while intoxicated. Do you understand what you're charged with?
I do not.
Here's where the courtroom chess match begins. Daniel refuses to even acknowledge the charge of drunk driving because in his view, no eyewitness equals no crime. But that's not how criminal law works. In OWI cases, police observations, field sobriety tests, dashcam footage, or chemical results often serve as sufficient evidence. The lack of an eyewitness doesn't invalidate a charge, it just means the prosecution has to prove its case through other means. The judge isn't asking Daniel to agree with the evidence just to acknowledge the charge. And his refusal, that only further signals how he's not engaging with the process the way the court requires.
There's up 1 to 5 years incarceration. The court can order probation, 30 days to 1 year in jail, or at least 48 hours must be conserved consecutively. The court can also order community service, rehabilitative programs. The court can also order your vehicle immobilized, can order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services.
And there it is. The phrase exclusive equity, a red flag for courts and legal professionals alike. This is classic sovereign citizen language, where defendants believe they exist in a different legal reality, one where they can opt out of state jurisdiction, contracts, and even criminal liability. But spoiler alert, courts don't recognize personal interpretations of the law. Saying you're a trust or claiming federal registrations won't shield you from charges like fleeing and OWI. Judges are required to treat all defendants equally under the law. And Daniel's strategy, while dramatic, won't exempt him from the same legal consequences others face.
Given that the defendant is talking in English, that he understands English, understands the nature of those charges and what he's charged against.
So malicious prosecution by Washington County prosecutor as usual.
Sir, there is great peril in representing yourself. You will be held to the same standards as anybody apply or for.
This is a matter under the Eastern District of Michigan Federal Court. Case number 2511226.
We're not represented by counsel. I would further indicate, sir, that at any point during these proceedings, if you wish to be represented by counsel, you can make that request to the court and counsel would be appointed to represent you. Because of the defendant's conduct in the past in not acknowledging the court and what the court is saying, the court does make the presumption that he does speak English. He understands that. I would further state on the record that Mr. Magoo has been through this process before. He does understand that if he does wish to be represented by counsel, the court would give him counsel or would have counsel appointed to represent him in this matter. In the case 25F30979, in that case, sir, you are before a complaint that alleges that on or about July 3rd of 2025, count 1 is fleeing and eluding 4th degree.
Added on by the prosecutor's office after the fact.
That is a felony, punishable by up to 2 years incarceration and a $2,000 fine plus court costs, mandatory suspension by the Secretary of State.
My Secretary of State, anything is canceled. I have no contracts with the state of Michigan.
That is a misdemeanor charge.
This is a matter of trust, Your Honor. This is a matter of trust. I am protected under a trust.
90 days in jail, a $100 fine plus court cost. Count 3 on that complaint alleges operating a motor vehicle without security. That is a misdemeanor, not punishable by not more than 1 year incarceration and not less than $200 nor $500 fine plus court cost. Count 4 is operating while licensed, suspended, denied, and or revoked. That is a misdemeanor.
All of my registrations are through the federal government. I have federal.
This is a big one. Daniel insists he holds an international driver's permit and therefore isn't subject to Michigan law. But let's unpack that. International permits only apply in conjunction with a valid domestic license and only for visitors, not residents. If your Michigan license is suspended, revoked, or canceled, no international permit overrides that. And using one to avoid state driving laws, that can actually make things worse. So here's a question for you. Should courts offer more legal education to self-represented defendants, or is this just a misuse of the system? Let us know what you think.
Appointed, the court would consider or would appoint counsel to represent him in this matter. and he apparently wishes to proceed.
Were you served your notice
Having
and summons
notice
for federal
of
court?
the charges, sir, do you wish to still proceed without an attorney?
I just want to know, where do you get
Do
your
you
powers?
wish
Are
to
you an Article
proceed?
3 judge or an Article 6 judge? Where
Do
are your
you
vested
wish to
powers? Can you
proceed
answer
without
that?
This moment right here is tense. Daniel openly challenges the judge's authority, asking whether he's an Article 3 or Article 6 judge, a constitutional reference that doesn't apply at the state court level. And the judge, calm but firm. "See how much authority I have," he says, then proceeds to continue the arraignment. Judges don't need to argue their constitutional standing with defendants. Their authority comes from the state constitution and laws, not a defendant's belief system. Still, it's hard not to feel the heat in the room. Daniel's pushing boundaries, and the court is quickly losing patience.
I was just admonishing him of the perils of representing himself, and that it requires in part that I let him know what he is charged with, and I've read them kind of in fully, more so than I would have, because he refuses to acknowledge those. So I am satisfied that he now knows all of the charges that are against him.
Thank you, Your Honor. The people would like to be heard on bond when appropriate.
All right. What do we want to set this for? Do you wish to have a preliminary examination, sir?
This is a matter of a federal matter now, Your Honor, under case number 2511226, under the Eastern District of Michigan, under the Honorable Mark A. Goldsmith and Magistrate Judge David R. Grand. There is no proceeding here, Your Honor.
There is no proceeding. Oh, there's a proceeding.
Well, malicious prosecution is what the proceeding is.
Okay, very good. Do you wish to have a preliminary examination?
There's no proceeding, Your Honor. This is a matter that should be stayed and
What is
dismissed.
people's position on whether or not we should set this for a preliminary examination or adjourn the probable cause?
Your Honor, I don't know if the defendant has received all discovery in this matter as he is representing himself, so I would request a probable cause date, potentially.
Because you've got to send it.
Yeah, and who restricted my phone calls?
Conference. You know what? You're going to have to stop interrupting. I will give you an opportunity. You've been before me before. I will give you an opportunity to say whatever you want to say, but I'm not going to have you interrupt me, and I'm not going to have you interrupt the people when they're talking. As long as you were saying.
Thank you, Your Honor. I have to there's video evidence in addition to the paper discovery. I've got to make arrangements with Lieutenant Arnett to work on that. So it may take just a bit longer. I would potentially look at the 7th, maybe, if the court would have entertained that, and then I will wait to be heard on bond when the time is appropriate.
I will adjourn the probable cause August 7th, 2025, 9 a.m. As to bond.
Your Honor, I've been reviewing ex-jail, and I wanted to double check if the defendant had been arraigned. It's not clear to me from a couple of different things, but it does appear that he has been set with a $10,000 bond in 25F30979, as well as 25F40523, each $10,000.
Yes.
Your Honor, I do think it's important that the court have some additional information, and I would like to ask the court to revisit the issue of bond. First and foremost, I think it's important the court know that the facts alleged in the newest case, the 25F30979, it does include the fact that the Michigan State trooper who pulled the defendant over noted in his police report that the defendant had a license plate on his vehicle that indicated he was a diplomat and that he refused to identify himself. He refused for quite a bit of time. Additional units had to be brought to the scene from the sheriff's department in order to for lack of a better term, deal with the situation. And ultimately, they were able to identify him as the defendant, Daniel Magoo. The concern with that goes along with the other case, which is an OWI. It is charged as a third. I will note that it is a true fourth, to the best of my understanding. So there does appear to be an alcohol problem going on. And I also think it's important for this court to know, because I don't know that the court knows the defendant has.
This isn't just about traffic stops and licenses anymore. The prosecutor drops a bomb. Daniel is now facing a third open case involving telecommunications abuse tied to a domestic relationship on top of his other serious charges. What does this show? A pattern: alleged failure to appear, claims of diplomatic immunity, repeated offenses, and now potential domestic-related misconduct. This raises serious questions. Is this defendant gaming the system or genuinely lost in a legal philosophy he doesn't understand? Either way, the court must protect the public and ensure accountability, and it looks like the judge is preparing to act.
Trial in April of this year where the defendant failed to appear. And there were jurors, there was a veneer that had been brought in. And I bring all of this up to say, Your Honor, that the people are concerned about the defendant's ability to remain law-abiding, because I'll also note for the record that at the time that the new resisting, obstructing, fleeing, eluding case and the telecommunications malicious use case came up, he was in bench warrant status before Judge Slay, is my understanding, for refusing to come after the case here had been found over, refusing to appear in person. I say all of that to say this: I do think that $10,000 is too low, and I also am going to request a scram tether because this is an OWI 4th alleged, as well as a GPS tether, given his history of failure to appear and failure to comply with court regulations. Thank you, Your Honor.
Is the bench warrant before Judge Slay still out?
She has bond denied in her case now.
His bond's been denied in that?
Yes, that's correct, Your Honor.
Got it. Anything you'd like to say?
Anything to do with any contracts with the state of Michigan are void ab initio for a matter of law, as I have an canceled driver's license and I have an international driver's permit. And that also relates to the Canton case that they're trying to stick me for a driving unlicensed suspended citation, in which that I have an international driver's permit, making it also void. All of my matters, including the vehicle that I'm registered under, are registered to the federal government, not the state, under the Federal Motor Carrier Safety Administration. All of these charges are frivolous and a part of a long pattern of malicious prosecution by Ms. Londy, the Washtenaw County Prosecutor's Office, and quite frankly, you, Your Honor.
Hearing argument regarding bond, the court does believe that it was an abuse of discretion given the circumstances of this defendant to set his bond at the $10,000 figure. After hearing argument, viewing the file, the court does believe that not only does the defendant pose a risk to the public,
No
I
victims.
do believe that the defendant is a risk of flight given those circumstances, and has indeed, or at least is charged in this case, refused to obey or fled and eluded.
That was added on afterwards. The
Police
police officer did not report that
Those
at all.
reasons the court, given those circumstances, would in each case raise the defendant's bond, grant the people's.
What a ride. From claiming diplomatic immunity to questioning judicial power, Daniel M. S. arraignment was anything but ordinary. But despite all the legal jargon, federal references, and courtroom defiance, the judge remained focused on the facts and the law. With 3 open cases, serious charges including OWI 4th, fleeing, and a domestic abuse-related charge, the court decided to raise bond and apply monitoring conditions. Whether Daniel truly believes he's exempt from the law or is using a sovereign playbook as a delay tactic, one thing's clear. The courtroom will always answer ideology with procedure. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Welcome back, courtroom watchers. Today's case dives straight into the chaos of housing court, and it is messy. We've got a tenant, Jacqueline King, fighting for a 30-day extension to move out, while the landlord's legal team pushes for immediate dismissal over $79 in unpaid rent. You heard that right, $79. But it's not just about the money. This case peels back the layers of subsidized housing laws, ledger manipulation, and last-minute interviews for survival. And wait until you hear the judge. He's had enough of these circular arguments. Is this a tenant fighting back against bad faith tactics or someone skirting lease obligations? You decide. Let's get into it.
This is ridiculous. No, it is simply what your argument is ridiculous.
Town Center Place versus Jacqueline King.
She can have a seat there. All right. This is your motion.
Your Honor, we request per COD that Ms. King be granted an additional 30 days to move. As per the terms of the COD, her condition was to show that she has been looking for new housing. I provided a letter from Ms. Little from Housing Bureau Senior showing the properties that she's applied to. Since that letter, she's even applied to even more. She's been accepted at about 3 of them, but she hasn't had her interview yet. And then even after she has her interview, there's no guarantee that the apartment will be ready in a certain time. And I also filed a
So when are her interviews?
Would you mind if Ms. Little comes up?
Yeah. That's fine.
Take the name of the record.
Okay.
So yeah, so Ms. King has been selected for 3 apartments. And one specifically, she's in the process of an interview. We don't have a date yet because we're still seeing the paperwork. It's a really long process to get all of this done.
All right, pause right there. The defense is painting a picture of a tenant doing everything right, applying for new apartments, landing interviews, and trying to escape a bad situation. But here's the twist. Timing is everything in housing court. Even if Ms. King is making progress, the judge is laser-focused on whether she followed the exact conditions of the COD court order of dismissal. So the real question becomes, is effort enough when legal timelines are rigid? And how much leeway should someone in subsidized housing be granted when navigating complex housing systems? Let us know in the comments what's fair here.
All right. Thank you. Response.
We're asking, for a writ for the conditional order of dismissal to be enforced. Part of the conditional dismissal order was that she paid rent, she paid full rent, she paid timely rent. And we've informed her, as you see in the answer, of she recertified, her rental increase went up to $270 a month, and she's still been paying $247. So she owes currently $79. And she was supposed to pay on time, full amount of rent stated in the conditional dismissal. She has not. She's been informed that she had been paid by a letter that had been paying less both times, and she.
Now here's where the fire starts. The landlord's attorney is coming in strong, accusing Ms. King of underpaying rent after a rate increase and using that as grounds for eviction. But notice the wording: she paid on time, just not the new amount. The dispute? A $79 difference. But in subsidized housing, late or partial payments aren't always clear grounds for eviction, especially if there's a ledger dispute or unclear communication. Is this a case of bureaucratic gotchas, or is the landlord enforcing terms that Ms. King clearly signed off on? Drop your take below. This one's nuanced.
She has paid. However, I've asked on more than one occasion for a complete ledger. This ledger starts in April of 2020. Ms. King has lived at Town Center for at least 8 years, and she's been in this new apartment for.
When was she recertified?
She was recertified.
I think it's in April or March.
It was January 16th, 2025.
January of this year.
Yes. The effective date was March 1st, 2025.
Of the rent. So it's March and April. That
And go ahead. Your Honor, as part of the terms of the consent order for conditional dismissal, we were to wipe her ledger as
I recall. I
We
recall.
did that. So before that date, shouldn't be in controversy here.
Well, that's what I was curious about.
Your Honor, the reason it's in controversy is because they wiped her account and included her February's payment, supposed to be February 7th, and they wiped her credit. Now, what my understanding of wiping her account was to remove the charges that she had had since.
She was to zero out, that's what was supposed to happen.
Okay.
Things just got even messier. The defense argues that the landlord's ledger conveniently wiped out Ms. King's credits, essentially erasing proof she paid more than owed in previous months. If that's true, this isn't just a math issue, it's a credibility issue. Are landlords manipulating financial records to evict vulnerable tenants, or is this just sloppy accounting caught up in a legal tug-of-war? Either way, it's clear the judge is growing frustrated, And if there's one thing you don't want in court, it's a judge who thinks you're wasting time.
And not paying the full amount of rent is not a, eviction cause for subsidized housing. They are, required to offer payment arrangements. The goal is for subsidized housing.
She entered into a COD that she was gonna pay her rent timely.
No, COD says she would not violate her lease. This is not a non-payment of rent case. Never has been.
Does she have the 79?
Yes, Your Honor, she has $79.
Then why are we arguing? Why doesn't she pay it?
Because she has credit on her account, Your Honor. It's not fair for them to keep the credit, and they reverse the half payment at a different
All right.
time. And it's not a
This
violation- it's not a violation
is
of the lease.
ridiculous. No, it is simply what your argument is ridiculous. Because what I'm gonna do is she was to abide by the terms. She has to pay her rent on time, got her account zeroed out, gave time for her to find new housing, gave an opportunity to then come before the court and ask for additional time if she showed that she was doing that and complying with the COD. She's not in compliance with the COD. I'm gonna deny the motion to extend the time.
Your Honor, thank you. Yeah, how is she not in compliance with the COD? It doesn't specifically say that she has to pay her rent one time.
It
or the
does.
full amount. It does.
It does.
It has things for late payments. It has other things that if you go to paragraph 23 or whatever, it lists the things that you can terminate. Do you have?
You sign, I'm sorry. Your Honor,
Yes.
the second line from the last line says defendant will pay March and April rent at normal time. Your signature is right here.
And she pays on the 5th.
She did not pay her full rent, ma'am.
Okay, but she paid on the 5th.
She didn't pay her full rent. We can go round and round in circles. Motion denied.
And there it is. Motion denied. The judge cuts through the noise, the accusations, the math gymnastics. He wants compliance, not chaos. According to him, the COD clearly stated the rent had to be paid in full on time. Even if Miss King had credit or paid close enough, that wasn't enough to satisfy the exact legal terms. But this raises a deeper question. Are these legal documents truly fair to tenants navigating confusing systems and unreliable information, or is precision the only way to keep order in the courts? Sound off, was this ruling just or unjust? What a whirlwind. We watched a tenant try to make her case armed with housing letters, applications, and receipts. While the court held her to the strictest interpretation of lease terms, the judge made it clear effort isn't enough. Legal compliance is black and white. Whether you think this case was about $79 or systemic pressure, it shows how unforgiving housing court can be, especially for those in subsidized housing trying to stay afloat. If you found this case as shocking as we did, hit that like button, drop a comment with your take. Was this justice served? And don't forget to subscribe for more jaw-dropping courtroom breakdowns. New drama hits every week, and you won't want to miss what's next. From the moment Daniel Bernstein steps forward, you can feel the weight in the room shift. This isn't just any sentencing. This is the culmination of months of emotional trauma, financial deception, and shattered trust. Judge Boyd doesn't waste a second laying it out. Multiple counts of wire fraud, aggravated identity theft, and conspiracy. The courtroom is dead silent, everyone's waiting for what comes next. And it's not just what he did, it's who he did it to. The victims weren't strangers, they were people who trusted him. Family, friends. Viewers, keep watching, because this case goes from betrayal to full-on psychological warfare.
You were here at the last hearing,
I was not. I was attorney.
and she's overseas serving our country. You're aware of that?
Attorney Landman did indicate that she had said that. We don't have any proof of that other than her statements, but I'm not.
I can look in her background. I also saw some uniform and military paraphernalia at the last hearing, and I'm gonna tell you, she's overseas.
I'll take her word.
All right, I mean, I'm not gonna even question that part of it. But given that fact, my understanding is there's something that has to be moved from the unit, from the property.
Inside the unit.
Pardon?
The trailer, just assorted things need to be relocated.
Okay, and my understanding, I think the gentleman that was here the last time, was that Mr. Contreras, ma'am?
Correct.
That-
My husband.
Okay, he had indicated that they were basically waiting for her to come back stateside. That's my understanding.
Here comes the prosecution, and they come in sharp. The government's not mincing words, they're painting a picture of a calculated, deliberate betrayal. Daniel wasn't just stealing money. He was manipulating emotions, forging documents, spinning lies so elaborate they took months to untangle. What makes it worse? His charm. This is someone who smiled while scamming people blind. Prosecutors say he knew what he was doing and he did it anyway. Again and again. It's one thing to commit fraud. It's another to do it with zero remorse. If you thought this was going to be a light sentence, you think again.
A significant health hazard or life-threatening in any
No,
way?
Judge.
All right, because, and I stated this to Mr. Landman, I am not going to, unless forced, issue a judgment against military personnel that's overseas serving. It's just not going to happen. I think I made that clear. If you want to take it to another judge to do it, that's fine, but I'm not doing it. That's bottom line. So what I'm going to suggest, if she's anticipating being back, then you're going to, I'm going to say, put it out a month, let her get back, or at least a month, and let her get back and then assess the situation and try to figure out what to do.
That's understandable, Your Honor.
All right. All right. And what branch did you say you were in?
Army?
Oh, that's right. So maybe I'll change my mind. No, I'm kidding. All right. Why don't you give me a date? About 35 plus days out, please.
August 15th at 3 p.m.
All right. I'm going to adjourn this to August 15th, 2025. You said 3 p.m.?
Yes.
At 3 p.m. Okay?
And this will be an in-person, correct?
This will be an in-person hearing. If for whatever reason you're not back, then what you can do is you can sign in, or somebody can let us know that you're not coming back at that particular point in time, and we'll figure something out.
Okay.
Okay?
Yes.
When Judge Boyd leans forward and says, "Let me stop you right there," you know he's not buying any spin. This is the first moment we see his courtroom authority in full effect. He's not angry yet, but there's a quiet fury behind his words. He's not going to let the defense dodge accountability. This isn't just about restitution or jail time, it's about the why behind it all. Why did Daniel think he could get away with it? Why did he believe these victims didn't matter? And Boyd, he's just getting started.
Carlos Hicks.
All right. And what are we here on? We are here on a...
Defendant's motion to set aside the default judgment, Your Honor.
All right. And what's your basis, sir?
Huh?
What's your basis? So why do you want this judgment set aside?
Because literally just got relocated to a condemned spot.
Say that again. please.
I got relocated to a condemned.
Okay. So we back up. You were at Arbor One.
Mm-hmm.
Then you went, they relocated you to
the
villas
townhouses.
across the street.
And that's even worse. I haven't had no hot water in since 2 months, 3 months.
Okay. And so did you sign a new lease with them?
I never signed a new lease. I still have the old lease from last apartment I was in before they relocated.
Okay. So the only lease you have is the Arbor One lease.
Yes.
Okay. All right. So Mr. Hicks, when they moved you to the villas over across, right? To your understanding, what was the arrangement of what your tenancy would be?
When they moved me, I was still active going to a court with y'all before. So I was still active in court with y'all. So then when they relocated me, I was still active going to court with y'all. So I still got another court date with y'all. August.
And that was when they were before me, and I was telling them they needed to relocate people.
Yes.
And so then they moved you over there.
Mm-hmm.
Did you sign anything saying that you were going to pay rent?
No.
This is the moment that breaks people. The victim's letter isn't just emotional, it's devastating. We hear about the sleepless nights, The ruined credit, the humiliation, and that gut punch line, "You smiled at my children while stealing from their college fund." It's chilling. You can see jurors looking down, even Daniel shifts in his seat. This wasn't some abstract crime, this was a personal violation. A home invasion of trust. If you've ever been betrayed by someone close to you, this part hits hard. And Judge Boyd, he hasn't even ruled yet.
No, so I hear you kind of on that. They took a judgment for 1909. Counsel, and you may or may not know, was there something signed as to what he was gonna pay?
No, but obviously he's still gonna be obligated to pay rent if he's moved to another property. If he's not, he can't just live there for free. And the fact that he has moved over to the other side was because of the repairs that needed to be made to the 14A side.
I got you, but so when he didn't appear on June 27th, somebody, hold on a second. Somebody came up with a figure for the judgment of 1909.69. So if he didn't sign anything, or there wasn't some other type of agreement, I'm trying to figure out where that number came from.
It was the rental obligation that he would have been under if he was still in the other property. So he's moved over to the new property, he still has to pay rent.
Okay. So they took what his rental amount was when he was over at RB1, and that's what he was supposed to pay.
So
That's my understanding.
Yes, go ahead.
So, once, other counsel, I'm sorry, I forget, Mr. Ingram, and I just had a conversation regarding Ms. McGuire's case, and it sounds like Mr. Hicks' case isn't.
Now the defense steps up, and honestly, it's a tough listen. They're pleading for leniency, pointing to Daniel's troubled upbringing and his potential for rehabilitation. But here's the thing, potential doesn't undo harm. And the victims, they weren't given leniency. They were left picking up the pieces while Daniel moved on like nothing happened. Judge Boyd isn't buying the excuses, and neither is the public gallery. You can feel the tension rising. This isn't about second chances. It's about justice, and it's about time.
Hold on. Don't talk, you're winning. Okay.
And I apologize to Mr. Hicks. He tried to talk to me when I was speaking with Ms. McGuire, and I didn't get a chance to get it. And Judge Washington has several of these cases before her next week regarding the same issue.
So here's what I'm gonna do on this one. I'm gonna grant the motion to set aside the case because venue was improper. This case is to be transferred to 14B. All costs associated with that transfer of the case will be borne by the plaintiff. All right. So just so that you understand, case doesn't disappear. If they file all the paperwork and do everything, it's just going to be heard at 14B.
all right.
All right.
Okay.
Okay. Good luck to you.
Thank
And you did a good job being quiet when you were ahead. BO Properties versus Rika McGuire.
I'm sorry, Your Honor. Was this Ms. McGuire?
Yes. There she is. Come on.
And yeah, I think you're already apprised of the situation.
Yes.
Your Honor.
We'll oppose transfer in this case.
Min Kim on behalf of Ms. McGuire, and Ms. McGuire is here today as well. Do you want to speak? The parties had time to discuss the matter and have agreed to transfer the case to 14B District Court.
Case is transferred to the 14B District Court. All costs associated with that are to be borne by the plaintiff.
Thank you, Your Honor.
Thank you. Take care, Ms. McGuire. BO Properties versus Jason Mitchell. Hello, what's your name?
Jason Mitchell.
All right, where are we on this case?
Your Honor, this is a non-payment case. Right now, the outstanding balance is $30,660.
Listen closely here, Judge Boyd's tone changes. It sharpens. He's had enough of the deflections. You hear him say this wasn't a mistake, this was a pattern. That line cuts through the courtroom like a blade. And he's right. Fraud like this doesn't happen by accident. It's planned, rehearsed, and executed over time. Boyd's not just sentencing a man, he's sending a message. If you weaponize trust to destroy lives, the consequences will be severe. This is the beginning of the end for Daniel, and we're just getting to the heat of it.
4 o'clock. And some of the things were not what we verbally agreed on.
Who were you talking to?
Was Hunter with Beal. We kind of came up with some terms. It's different terms. And the biggest problem I have is a few of the terms put me in a position in order to, I guess, complete the terms, I have to break federal and state laws. So I don't feel comfortable doing that. And if they would work with me on that, I'd be happy to.
Do you know anything about the agreement?
He's referring to an attempt at a conditional dismissal, and it has to do with the transfer of the liquor licenses. That's not our position at that time, at this time, rather. Right now, we're just looking for an actual judgment. However, as I said, we are willing to work with him as far as actually winding down.
Can I show you the agreement, please?
Hold on. Well, this is kind of odd because the plaintiff or representative of the plaintiff gave him a proposal. He's what, and just so that I'm just transparent on the record, I don't, he can't go along with the agreement because in part, he believes that part of that agreement is illegal.
I'm not privy to that agreement. All that I know is that
Okay.
indicated that he did attempt to settle it, however, because of the defendant's objections, we've backed off of a settlement in whatever terms they were doing. And that now they would like.
Well, I'm not gonna grant a judgment because obviously there was an agreement. He's saying, and so you correct me if I'm wrong, I can go along with this agreement. I just can't do these illegal things.
Yes, that is correct.
And if that's the case, I'm not going to allow plaintiffs to say, well, you can agree with me, but you have to do something illegal in order to keep your,
Nobody's trying to get him to do anything illegal to judge. I think it's just a misunderstanding on his part. If you want, we can pass this and I can speak to him outside.
well, you can speak to, I'm going to do this because I think you should probably look at the agreement and make sure that what they're asking of this gentleman is the proper thing. I'm going to adjourn this to the 18th,
Thank you, sir.
2025 at
Well, yeah.
1 p.m.
Yeah. I want
Okay,
counsel to look over the agreement first.
there you go. All right.
All right, thank you.
Welcome to a courtroom showdown that exposes the brutal reality of failed housing promises, legal gray zones, and families caught in the crossfire. Today's case centers around Rico McGuire and a string of shocking developments involving condemned buildings, red tag notices, and tenants left in limbo. We've got parents with school-aged children being shuffled between hotels, ceilings collapsing in supposedly fixed units, and even court orders being challenged by misinformation at the door. You'll hear raw testimony from tenants pleading for heat, safety, and clarity, while the court fights to untangle the legal web of responsibilities. But here's the real question. Can this court balance law, humanity, and urgency all in one hearing? Stick around because this one's more than just a court date, it's a community on the brink.
Has not been relocated. I want to hear from the tenants. I want to hear from the city of Ipsy, but I think, or the city of Ypsilanti building officials, but we've got to deal with that immediate problem. There are then two individuals who, Miss Llewellyn and then Grove, who we sent questions to, and I disclosed it to council, basically asking, did they wish to testify before the court? The other issue becoming whether or not they had been relocated. Again, I think the second thing I just brought up is the most important thing.
And right out the gate, we hear from Miss Grove, one of the many tenants caught in this housing maze. She's recounting being moved from hotel to hotel, juggling school drop-offs and unreliable repairs. But here's what stings: after weeks of disruption, she's still uncertain when or if her situation will stabilize. This isn't just about plumbing or paint, it's about dignity, it's about children, and it raises a critical point: should tenants bear the burden of mismanagement?
And so they moved us into a hotel for a week. And then when we were supposed to be coming home, they give us another confirmation for another hotel because they had not started when they were supposed to, which was supposed to be on that Monday. They didn't go through that whole week. They waited until like, I think it was Friday, perhaps, to actually start doing the work. And then so from that Friday, Saturday to the next week, we stayed in a hotel. And then last week we finally just came back because my son has to go to school. And we weren't able to go from like that part of Canton or that part of Ipsy directly to his school. And then they said, oh, and I'm missing a step before. I'm so sorry. There was a fourth hotel booked for last week for them to fix what they did wrong. But my partner did say, you know, can you guys like reschedule or something? Like, we really can't do this right now. So there was a fourth.
Okay, thank you.
Enter Miss Gambo. She confirms being offered relocation, yet the timeline is so fuzzy it feels more like a shrug than a solution. The court tries to piece it together. She was told to move, then got red tagged mid-process, and now what? Who's guiding these residents through the chaos? The judge's growing frustration is palpable and justified. The right to safe housing shouldn't require a legal degree to interpret.
Your kids, how many kids are you talking about that you have to try to get to school?
One that I have to get to school, and one is 3 and not there yet.
Okay, gotcha. So you have one that the issue regarding schooling.
Yes, sir.
All right. I'm sorry, Ms. Gamble. I just wanted to make sure to get that in. Okay, well, thank you. You know, it's just nice. You need to tell these people that because they weren't listening to me when I was going. All right. You haven't been relocated. Has there been an offer to relocate you, ma'am?
Yes, Lynette, offered to relocate me, 2 weeks ago. And the day that she asked me, I had to think about it. Then the next day I had to work, so it just didn't cross my mind. But she asked me on a Thursday. I don't know what day I came to see Alex Henry, but the day that I see him, that's the day that she asked to relocate.
All right. All right. Let me ask you this. How many people are in your unit? Just you? Oh, and a dog. That means there's 2, right? All right.
Yeah.
So would you like to be, well, you have to be, which is the real issue.
They gave me to the 15th, which was tomorrow. So had I been relocated to a hotel that she claimed that she was going to put me in, I would have came back to the rear tag anyway. So I would have had to leave again regardless. Because I got the red tag on my unit door last Wednesday.
Okay, so say that to me again. I want to make sure I'm understanding.
Okay. The day that she asked me was on a Thursday. That following week, which was last week on Wednesday, I got the red tag. When she told me that she would give me a hotel, it was going to be until April 15th, which is tomorrow. So had I been in the hotel this entire time, I would have had to come back and leave again.
Okay, so let me ask you this. If the issue wasn't resolved by the 15th, what you had to come back. So nobody told you what would happen on the 15th?
No, I just assumed that the hotel would be up and I would have to come back.
Okay. All right. Pardon?
So I'm trying to bring you peace, not pain.
Gotcha. No, it's okay. Mr. Freeman?
I just didn't hear it. So I could hear better.
Oh, okay. You heard the last part that she indicated that on the 15th, she believes she had to come back because there's nothing.
Here's the heart of the confusion. The judge is trying to nail down who knew what and when. Miss Gambo thought she'd be booted from the hotel on the 15th, but no one gave her anything official. This isn't a minor paperwork issue. These communication gaps create real-world panic for people already teetering on the edge. What would you do if your kids had nowhere to sleep tomorrow?
She wanted to know if I wanted to be in a hotel in Ypsilanti or in Arbor because I go to school at Washington Community College and I work at University of Michigan Hospital in Ann Arbor. She wants to know where I wanted to be at as far as a hotel.
But you don't know. All right. So where do you want to be?
I want to be in another apartment. I don't want to be in a hotel.
I know. Stay right there. So here's also part of my concern. As it stands right now, these individuals being relocated to hotels, they can't go back or aren't supposed to be going.
Finally, the judge cuts to the chase. What is the long-term plan? Temporary hotels are fine in a crisis, but this isn't sustainable, and here's the shocker, the officials don't have a real answer. They admit units aren't ready, people can't return, and we're working on it is all they can offer. This is where systemic failure becomes personal trauma.
Or the villas or some other certified unit. But it's not, they're not all available immediately. So we're putting people in hotels because they can't be in the buildings. So we're putting people in hotels till we can find them places. This is not, it's not feasible at this point to just say that everybody. Plus, remember, until the latest red tagging, we were working on getting their units back together and fixed up so that a lot of them could go back because that's.
Okay, so
I'll find it.
okay, no, it's okay. All right. So, Miss Fluellen, you have already moved. Is that correct? Oh, you just muted yourself.
Okay, yes, correct.
Okay, so you already have another unit.
I moved out. I'm not dealing with them at all. I moved to a whole
Say that to me
complex.
again.
I moved to a whole different complex. Not with them.
Got it. Okay.
Due
All
to
right.
black mold, so uncomfortable in my home with the maintenance people just entering my unit.
Okay. All right. The individuals that are in back, who are tenants in there? Okay.
Erica Reed would also like to speak to the court about her relocation issues.
Ms. Reed? All right. Come on out. No, you can, I'll make you guys share the podium.
I have a question.
Oh, hold on, Ms. Llewellyn. Hello, what's your name?
Okay.
Okay. And so, have you been relocated?
Yes.
Where to?
72, Delaware.
Okay. All right. You said you wanted to tell me about.
Yes, Your Honor, she hasn't had no heat since day one, and her ceiling has caved in. They keep promising her a new furnace. She is the tenant that has been living in the hotel, paying out of pocket for over 2 weeks now.
Need that file too, please. All right. And all of that's correct, ma'am?
Yes.
So.
Now we meet another tenant who moved into a new unit only to find water-damaged ceilings and flooded floors. She's now bouncing between a hotel and her mom's home. Can we take a second to process this? A building condemned for safety issues gets replaced with another dangerous unit. That's not relocation, that's recycling dysfunction. And yet again, it's the tenant paying the price.
The floor was full of water. The ceiling was full of water.
Hold on. That was the new unit that you moved into?
Yes. So the same issue occurred, The tub was falling out of the.
So where are you now? You're in a hotel.
Well, back and forth from my mom's house and the hotel. He said they were gonna bring a furnace Thursday. They brought the furnace.
What's your name? You got that one. What's the last name? Is there a case pending, sir? There's not. What did you want to? Why don't you come on up? We'll just squeeze you all in there. Can you spell your name, please?
Bravey. Last name Johnig.
Okay. And what did you want to tell the court? Although I don't have a case before me regarding.
And he says, thank you. I've asked for heat. I was told several times that he works. Finally got a heater after I was berated and degraded. I asked him for heat, and I was told that the heat was fixed by the certified boiler operator. I was asked for the heat back. I said, no, I'm holding myself one of the leaks from the neighbor down to my tub. So it's a big hole. And there's another leak where on the left side where the toilet is actually sinking down. So it's just a matter of time to fall. I expressed to them that I'm disabled. I have 2 spinal fusion surgeries that I'm weak from. So when it's cold, I'm in pain. And my nerves and shit. Said, when the heat burns, I said, it doesn't. Please. Since January 2nd. And then February, 2 days ago, I got the red stick, which indicated that February the 2nd, the place was working again. So I'm back to I can't have your video.
What was your last thing?
My daughter always wants to visit, but it's too cold. It's not happening. It smells spoiled.
This is one of the most heartbreaking moments in the hearing. A disabled tenant describes heat issues, leaking tubs, and being denied basic comfort. He struggles to get through his words, but the message is clear. These are not just inconveniences, they're violations of human rights. Shouldn't vulnerability demand more protection, not less?
I'm not gonna cram any more people up here, maybe, I don't know. That's Mr. McGuire back there, right? And then,
Your Honor, there was one more tenant who had to leave to take her final exam, Jayla Evans. She
okay,
says she has not yet been reported.
Jayla Evans. And Mr. Friedman, do you know anything about Miss Evans?
She was offered a hotel. I think the 3rd.
So Miss Llewellyn is taking care of herself. Miss Llewellyn, have you guys talked to her?
Yes, we have. I think we were going to help her with a motion for escrow.
Okay. Well, I'll deal with that at some other time, but she's in that process. And has anything affirmatively been filed? I guess I shouldn't put it that way because that means something different now. But in terms of a counter complaint or anything else in the Grove matter? Did they? Okay. Mr. Friedman, was there anything else that you wanted to? Okay. I frankly thought it wouldn't have to be said, but when I listen to Ms. Reed, when I say relocation, that's into a place.
The judge takes the reins. With all buildings now red tagged, the new ruling is clear: relocate everyone, but not just anywhere. These new placements must meet state housing codes. It sets a sobering moment of clarity. Relocation doesn't just mean move them. It means protect them.
Further relocations that people are telling you, it's very discouraging for me to want to move into a place that they suggest, if you understand.
Yeah, no, I get you. And let me just explain to you. So for the cases that are before me, my primary objective, while having a different one when I walked in today, right? But now looking at everything, realizing that all the buildings have been red tagged, my primary objective is we need to get the individuals out. That really is it. But then when I listen to Reed, problem is, yeah, I gotta get you out, but I gotta get you out in a place that just meets the minimal requirements for health and safety. I mean, you can't. I could get you all out if I was gonna put you in a parking lot. I mean, but that's not.
I could get you all out if I was putting you in a parking lot. The judge isn't being sarcastic, he's making a point. It's easy to shuffle people around to make the court look active, but the real duty lies in making sure they land somewhere humane. Ask yourself, how many temporary solutions have you seen disguised as progress?
The tenants which are subject to this court's jurisdiction are to be relocated to units or places that meet Ypsilanti housing code and the state of Michigan housing code requirements. Because I've heard from them today,
I'm going to indicate that, um, I mean, do you have children that you're trying to deal with or no?
Yes, I have, 2 19-year-old twins.
Okay, okay. So there's 3 of you. Is that no? You're 4.
13, 14, 18.
Okay. Sir, for you, I hear you and I wanted to hear from you because now they are at least placed on some notice. I have to have a case before I can rule specifically on your case. And it's just you, right? Well, you and the dog. I'm sorry, I didn't mean to put it that way. I just that was an awful way. And I know my mom will raise me better than that. Just say just you.
Now we get into the weeds. Specific individuals are being ordered into code-compliant units. But even here, the judge emphasizes family stability and communication. No more bouncing from place to place. And most importantly, 3 days notice minimum before any hotel stay ends. It's a small step, but a necessary one. Imagine living on a 24-hour eviction timer.
Place for her to reside that meets Ypsilanti and state code. Ms. Gamble, same thing. She's to relocate to a place with and looking more toward permanency of residency, but it has to comply with Michigan state code and Ypsilanti code or the jurisdiction in which the unit resides. So that probably also should be part of that. And I'm also going to order that for the individuals in the Vance matter. Did they leave already? No, it's Grove and Vance. Yes, in Vance and Grove, that they are to be relocated to a suitable residence, with keeping in mind to cause least disruption to the family. We cannot have these relocations that are lasting at these hotels, particularly for families that are lasting a period in time without them having notification of the renewal so that they can stay there. So what I'm also going to order is that individuals that are relocated to a hotel, they are to be notified not less than 3 days prior to the expiration of the stay that they are going to be able to continue to stay at that location. The intent is you just can't put them in there and, like Ms. Campbell was saying, well, I'm out on the 15th and I got to come back. Or like the Groves where they're bouncing around and then they all of a sudden end up back at these condemned units because they can't be there. Sir, I've given a general order. It really doesn't necessarily apply to you, but if once I have a case in front of me, my intent is going to be to have this gentleman relocated immediately to a suitable location. And as to Ms. Evans, who is not here, but I've heard from council representative, she is also to be relocated. Do you know how many are? Okay, but she is to be relocated in accord with the order. So those are specific relocations that need to take place now. To relocate, all of these individuals are to be relocated by Friday, 5 o'clock.
Your Honor, Mr. Friedman indicated.
Go ahead.
That plaintiff would reimburse.
Big win here, Miss Reed is getting reimbursed for her out-of-pocket hotel costs. But only because she brought receipts, worked at the hotel, and raised the issue in court. Let's not sugarcoat it, this is rare. Most tenants wouldn't even know they could ask. Which begs the question, how many people are quietly absorbing costs they'll never recover?
Your cost of staying at the hotel?
I can get it from, because I was staying at the hotel that I work at.
Okay.
Yes, and they gave me a discount for it. I think that's a night.
Got it. Okay. So I want a copy of your out-of-pocket expenses. I need you to submit a copy to the court. I need you also to submit a copy to, are you representing her or no?
Her answer is confirmed for answering counter complaint, but I have to.
Okay. Get that bill to legal services or that bill. So the court wants a copy. They want a copy. I also would say to get one to Mr. Friedman, but what I'm going to let happen is you get that to legal services, and I'm going to order as part of the order, and if you would, Ms. Kim, prepare an order that they are to reimburse her for her out-of-pocket expenses. Okay. All right. Was there anything else? Yes, Mr. McGuire.
I just want to know if I can get access to that list, my hotel room and stuff on 15.
Do you know about that, counsel?
Yes, Mr. McGuire indicated it expired on the 6th, so.
The 15th of this month, tomorrow? Okay, well, is his unit going to be extended? I mean, what's going to happen with him? You're in the hotel room now. All right.
This is extended.
All right, it will be extended. So. All right. Was there anything else from anyone?
Yes, Your Honor.
Yes, go ahead, Ms. Grove.
Miss Grove raises a powerful issue. Groceries, with 2 kids in a hotel, costs skyrocketed. The judge sympathizes but can't rule on it yet. This is a pivotal moment. Courts can order housing, but food, transport, dignity, that's a bigger conversation. Maybe it's time we started having it.
Is there any kind of reimbursement for that or per diem?
Ma'am, yeah, I understand what you're saying, and I'm not going to at this point order anything regarding that, ma'am. What I will do is I'm going to, unless there's an objection from counsel, I am going to check, see if there are resources within the county that may be able to assist individuals in this way, but I don't know at this point. Okay, ma'am?
No problem. Thank you, Your Honor.
Okay, I do hear you and I understand that. And that was something that was, while we were in back talking, was brought up regarding food costs, regarding also just trying to get kids back and forth from school and just additional travel costs and where are the resources to help folks regarding that. So it was brought up. I'm just not prepared to rule in on that at this point.
Totally understand, Your Honor.
All right.
Miss Grove raises a powerful issue. Groceries, with 2 kids in a hotel, costs skyrocketed. The judge, Miss Fluellen, brings up a complicated twist. Her lease expired, but she has money in escrow. Now what? This moment highlights the legal mess many tenants find themselves in: leases, deposits, repairs, all trapped in red tape. And if you're not legally savvy, good luck getting clarity.
I think you had mentioned that to us.
Yeah.
So what's your question to me?
Is possible I can break my lease, since I don't have a lease anymore? How do I go about breaking it and the money that I put in escrow on my own?
All right, there would have to be, you put money in escrow where?
At your courthouse in November.
At the courthouse.
Before you did a court.
Okay, there'll have to be a specific, okay, that would have to be specifically addressed by me if you were seeking return of that. And we did discuss that in the parameters of that. Ma'am, when you moved in, did you pay a security deposit?
I did.
Okay, and how much was that security?
I want to say $1,000. I'm not for sure.
Okay, so what I'm going to ask you to do, you guys have you been working with Ms. Williams? All right, I'm going to ask you to contact legal services. We also talked about the parameters of how all of that was going to occur.
Okay.
for people that have moved out and who would then be relinquishing any right to the unit and how we work that out. So I would prefer that you talk with them and then we can see where we can go from there, okay?
Okay, because the reason why I really moved out is when it rained, it floods, and my heat wasn't working, and I'm asthmatic. It's black bowl.
I got you. I hear you on everything. Let's just see if we can try to do the separation, how we're gonna do that, okay?
Okay.
All right. You had something else? No, I'm not. I was pointing at you.
Sorry. No, I'll just walk to the.
Okay. All right. Okay, folks, that's it. And then what I'm going.
Miss Grove raises a powerful issue: groceries with 2 kids in a hotel, costs skyrocketed. The judge, as the court prepares to adjourn, the judge makes one thing clear: this isn't over. April 28th is the new date, and he's keeping a tight grip on these proceedings. Why? Because when government and property managers fail, the court becomes the last line of defense. And this judge, he's making sure it holds.
Actually, to coordinate through legal services and counsel so that maybe they're staggered throughout the day so they're not here all the time. I basically set aside that time so that we can deal with all of this. That doesn't mean you can take it, but yes. All right, yes. I basically set that aside, but the way my life goes, you never know what's going to come up and what I will have to deal with. The gentleman from Ipsy, what was the day all of the buildings became red tagged? That, if you know what I mean, that was a very badly.
April 8th was the last day of the red tag buildings. The first red tag building was on the 21st.
Okay, so as of April 8th, all the buildings were red tagged.
I have a printed copy, but even just to make sure they have a date, maybe give them 7 days to respond so that all their things are put out.
Well, they shouldn't be throwing anything out of any of these units. I mean, it's almost the assumption has to be made that they've left their unit at least temporarily because of the condemnation. I think they've run. I'm not going to specifically address it, but I will.
Miss Grove raises a powerful issue: groceries with 2 kids in a hotel, costs skyrocketed. The judge, one final blow before the gavel: tenants are still receiving notices to pay rent to the wrong party. The judge is stunned and furious. He makes it crystal clear: if there's a case pending, rent goes to the court escrow or the city, period. Anything else smells like intimidation or manipulation.
I'm going to take a picture and send it to legal services so they can put it into the court. But yeah, it's still saying pay them instead of the court.
Pay the court or pay the city of Ypsilanti. All right. No, I got you.
Miss Grove raises a powerful issue: groceries with 2 kids in a hotel, costs skyrocketed. The judge, this hearing wasn't just a legal battle, it was a reality check. From red tag buildings to misplaced tenants, from flooded units to silenced voices, this case lays bare the hidden housing crisis facing too many communities. But thanks to this court, voices were heard, rights were defended, and change, however incremental, is on its way. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We break it down so you don't miss a beat.